This courtroom hearing started like any other, but within seconds, it exploded into pure tension. A defense attorney walks in already frustrated, and instead of calmly addressing the court, he immediately begins interrupting Judge Boyd. Before the judge can even finish explaining the schedule, the lawyer cuts her off, questioning why the case hasn't been called yet. His tone isn't just impatient, it's confrontational. You can feel the tension rising. The judge, calm and composed, explains that delays happen for a reason. Some attorneys arrive late. Some defendants are in custody and must be prioritized because of jail overcrowding. It's standard courtroom procedure. But the lawyer doesn't let up. He continues interrupting, implying the court is intentionally dragging things out to wear down his client. Then things take an even sharper turn. The attorney questions the integrity of the courtroom itself, suggesting that the judge is using the court's YouTube live stream for financial gain. That accusation instantly shifts the atmosphere. It's bold. It's risky. And it's completely inappropriate for a professional courtroom setting. Judge Boyd doesn't raise her voice. She doesn't lose control. Instead, she clearly explains that recordings only happen under her direction and that the court follows strict procedures. She repeatedly tells the lawyer to stop interrupting and allows him opportunities to speak properly, but he keeps cutting her off. At this point, it's no longer about scheduling. It's about respect. The lawyer's behavior begins to look less like advocacy and more like a public meltdown. Instead of helping his client, he appears to be creating unnecessary conflict. In a courtroom, professionalism matters. Timing matters. Respect matters. And when those lines are crossed, the judge has one job. Maintain order. What we witness in this exchange is a powerful reminder that in court, emotions don't win cases, professionalism does.
Acknowledgement of discovery been done because I don't have it in the court file.
I have signed a few of them at this point.
All right, so has there been any new discovery?
Not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going for 4 years. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
that, and it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what? I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I want to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bexar County,
For almost
that
20
there
years.
are cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what ends up
Hey, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases,
And you
right?
need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we
Have
accomplish
a nice
today?
afternoon, sir.
I
Sir,
mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually
reset.
occur.
sir.
And they're courts of exactly the same
Sir.
jurisdiction.
All right, Mr. Guzman.
Yes.
All right, so before the interpreter came, and correct me if I'm wrong, your attorneys came forward to let me know that they just received a new indictment. Is that correct?
Yes, Your Honor.
All right, and so that indictment, excuse me. Step away.
I was doing what the court ordered me to do and checking on the discovery.
All right, so what ended up happening is your attorneys, All right.
The courtroom was quiet, the kind of quiet that carries weight. Everyone was waiting for the next case to be called, expecting the usual routine, names announced, attorneys stepping forward, brief discussions, and then the judge making her decision. It was supposed to be just another normal day. But what happened next would turn this routine hearing into something far more intense. The defense attorney stood up, and from the very beginning, something felt different. His body language showed frustration. His tone carried impatience. And before Judge Boyd could even fully begin explaining the court's schedule, he interrupted her. It wasn't a polite interjection. It wasn't a respectful request for clarification. It was a direct interruption. Judge Boyd remained calm. She began explaining the situation, her voice steady and controlled. She explained that the court handles many cases every day, and delays can happen for several reasons. Sometimes attorneys arrive late. Sometimes cases before this one take longer than expected. Sometimes defendants who are in custody must be handled first because they are physically waiting in jail, and the court must prioritize them due to overcrowding. But the attorney didn't seem satisfied with that explanation. He interrupted again. This time, his tone was sharper, more confrontational. He questioned why his case wasn't being called sooner. He suggested that the delay was unfair. His words carried an edge that immediately shifted the atmosphere in the room. Judge Boyd tried again. She calmly explained the process. She made it clear that the court follows procedures designed to ensure fairness for everyone. She spoke with patience, giving the attorney a chance to understand. But instead of listening, he interrupted her again. Each interruption chipped away at the professionalism expected in that courtroom. Each time the judge tried to speak, he spoke over her. It wasn't just disagreement anymore. It was disrespect. The judge, however, did not raise her voice. She didn't react emotionally. She maintained control, reminding the attorney to allow her to finish speaking. Her composure stood in sharp contrast to his growing frustration. What made the situation even more tense was the fact that everyone in the room could see what was happening. Other attorneys watched silently. Court staff remained still. The defendant stood there, caught in the middle of a confrontation that was supposed to help his case, not hurt it. Instead of presenting arguments calmly, the attorney continued challenging the judge's authority. He began implying that the court was intentionally delaying proceedings. That the system itself was working against his client. These were serious implications. In a courtroom, every word matters. Every statement carries weight. Judge Boyd responded professionally. She explained again that scheduling decisions are not personal. They are based on logistics, availability, and legal priorities. She made it clear that the court's responsibility is to ensure fairness and order. But the attorney continued pushing. Then came a moment that stunned everyone. He brought up the courtroom's YouTube live stream. He questioned it. He suggested that the courtroom was benefiting financially from broadcasting proceedings. It was a bold accusation. One that directly challenged the integrity of the judge and the court itself. The room felt heavier. Accusing a judge of financial motives in open court is not a small matter. It crosses a line that most attorneys would never approach. Judge Boyd responded calmly, without hesitation. She explained that recordings are made only when authorized. That live streams exist for transparency and public access, not personal gain. Her explanation was clear, direct, and professional. But the attorney didn't stop. He continued interrupting. At this point, the judge had to remind him repeatedly to stop speaking over her. Her patience was visible, but so was her authority. She made it clear that there is an order to courtroom proceedings, and that order must be respected. The attorney's behavior was no longer just frustration. It was becoming a disruption. In a courtroom, professionalism is not optional. It is required. Attorneys are officers of the court. Their role is not just to advocate for their clients, but to do so with respect for the legal process. Every interruption weakened his position. Every accusation made the situation worse. Instead of strengthening his client's case, his behavior risked damaging it. Judge Boyd continued doing what judges are trained to do. She maintained order. She stayed calm. She explained the next steps. She gave clear instructions about when the case would be heard. She did not allow the courtroom to descend into chaos. Because that is the responsibility of a judge. Control, authority, order. The attorney, however, continued showing visible frustration. His inability to accept the explanation, his constant interruptions, and his confrontational tone created a moment that everyone present would remember. What stood out most was the contrast. On one side, a judge who remained calm, composed, and professional under pressure. On the other side, an attorney who allowed frustration to take control. The courtroom is a place where emotions must be controlled, where professionalism must be maintained, where respect for the process is essential. Because in the end, the courtroom is not about winning arguments through volume or aggression. It is about presenting arguments through professionalism, respect, and discipline. Judge Boyd demonstrated exactly what judicial professionalism looks like. Calm under pressure, focused on procedure, committed to maintaining order. And in that moment, the courtroom served as a powerful reminder of something every attorney is expected to understand. Respect for the court is not optional. It is the foundation of the entire justice system.